Good afternoon. Happy Saturday. Not legal advice. Like, subscribe, share. Send any questions, comments. I'm happy to respond. And I've pledged to be fully transparent. So hopefully, besides being successful for the benefit of the MMTLP community, hopefully it will demystify the process of arbitration. If you're involved in a arbitration in the future or in another matter, but hopefully you'll learn from that. And if you end up involved in one involving MMTLP, you'll get a preview. Today's question, what type of shoes do lazy people wear? And of course the answer is loafers. And again, thank you, little Bruce T out there, for that wonderful joke. Finra. So this is going to be a little bit about Finra in the respect that the arbitration, and I posted a prior video on this, I have filed for arbitration against Fidelity in a Finra-related proceeding. I have not withheld my disdain for Finra in submissions I have made. I also had a interesting exchange with regard to fees also. So I had requested the means to where I could pay the fees. I had also asserted various things about Finra that weren't totally kind. And the reason I was asserting that was I wanted to protect that issue if something unkind happened. And that arises out of my case in federal court that was dismissed by the federal judge, in that he said that disputes about arbitration aren't really for the courts to decide, it's before the arbiters to decide. So I asserted that in one of the documents I filed with Finra in my Fidelity arbitration, and in response, they dismissed the appeal. Not the appeal, the arbitration. So I responded, various things. I responded and I requested, let's say strongly, that they unwind that dismissal. They sent it to the General Counsel's Office of Finra, where that is apparently sitting now, and I filed another arbitration in the meantime and paid the fees. So in effect, I have two arbitrations pending, or potentially could have two arbitrations pending against MMTLP, and all that has been demonstrated to this point in time is Finra is, in my opinion, just my belief, is incompetent. So just in dealing with them procedurally, if they can't handle the process of an arbitration, then how could they handle the tasks that they are assigned? Anyway, so we are at an early point in the arbitration. I'll let you know what I hear from the General Counsel's Office. So there's been notice sent to the General Counsel's Office relating to my disdain for Finra, and he or she is going to respond. And then there's a second arbitration that I started already. So I'm confused, let's say, how they're going to handle that, but interesting. And if nothing else, it sets a record of how they are managing these things for retail investors. And I don't mind that at all. I don't mind setting the record so others can use that in the future. So again, quick reminders, based upon the amount of damages sought, it's either going to be one arbiter or three arbiters. If it's over $100,000 requested, it's three arbiters. $100,000 being your damage claim. That doesn't necessarily mean your stock value, because you could have other claims besides stock claims. You could have tort claims, and I explained that on a prior video, and I'll go over it again in a future video. In my particular action, I have three arbiters. So I will see how that turns out. We'll see how it turns out. Anyone, and I throw this out because I thought this would be interesting and would provide the community an opportunity to participate. and I will certainly make a selection that I think is appropriate. But anyone who is in the MMTLP community but who is not a shareholder and who is an expert as to what went on with regard to MMTLP, who would like to testify against either a broker dealer or analogous firm, please reach out to me. And I prefer it's a non shareholder because that would yield a more credibility because they'd have no financial interest in the outcome of the proceeding. That's why I asked specifically. So I want someone who's an expert but doesn't have a financial interest. I'll be interested to see what the General Counsel's office responds to in light of the exchange of communications that I have had with them. And again, I'm asserting that Finra has no right to arbitrate these matters. In effect, they should be appointed, and they haven't been properly appointed, amongst other things, besides the immunity, etc. So once that stuff is sorted out, and again, I have an expedited proceeding, whatever that means, but you can get an expedited proceeding based on age or medical reasons, and that should get you a decision faster than a non-expedited decision. And it doesn't cost anything to request that. So I requested it in my original action. I was granted, so I would expect it to be granted in the new action, but we shall see. But as soon as I get notice that the matter has been sent out for service to Fidelity, and I'm not involved in that process. This will be carried out through the Finra auspices. At that point in time, I'm serving discovery motions through Finra on the defendant. And I won't tell you the color of my betting or who I will depose, but it'll be an interesting fight. And I previously alluded to the fact that in arbitrations, or these arbitrations, there's a list of documents or categories of documents that Finra anticipates will be exchanged between the parties. And I indicated that at some future point in time video, I'll go through all the categories. But as to depositions, they have to be approved by the arbiters and by motion. So you have to file a motion, ask for approval, and you have to show why you need it. And there's various criteria. But in my case, the only criteria that would apply would be extraordinary circumstances. So there's a category that says you can get depositions if you can demonstrate extraordinary circumstances. And what occurred to me then is, wow, what an opportune thing Finra did by creating the U3 halt. I think that had reference to extraordinary circumstances or something like that. So it'll be interesting when I seek the depositions of various elements of Fidelity and Finra, how that is handled. And again, I'll keep you apprised as I make those requests. And those requests are going to be made, shortly. Along those lines, just so you know, to those who generally know my position, and there's not a lot of people that actually know my position in MMTLP, but they do know that I'm motivated by other things other than the share value, and that I promised and still promised to grind this out, as we all need to do. We all need to grind this out because that's the only way we're going to get this done. So let us see what's interesting that might arise from my arbitration. And again, since discovery will be initiated momentarily or requests, it'll be interesting to see what the pushback will be and what we will receive. And as to the documents that are obligated to be exchanged, I'm interested and looking forward to see what we get. So related to that, because I believe we have a righteous claim, because as structured, in my opinion, immunity, the way it's structured, should be against public policy, especially where entities who have some arbitrary status and are not really supervised by the government are given full immunity for criminal misconduct doesn't make much sense. And I think it should be against public policy. And I'm willing to challenge that. And because of issues related to non monetary actions and immunity that might apply to that, and again, criminal misconduct. And because they pissed me off recently again, I am going forward with the appeal against Finra in the Ninth Circuit. And the notice of appeal will be filed no later than Wednesday of this coming week, maybe Tuesday. And I'll be attacking the judgments for dismissal that were provided in the recent case that I had. And again, it'll be before the Ninth Circuit, which is a reasonably receptive circuit for consumers. So we will see how that goes. And, I have no amazing aspirations as to whether I win that or not. Appeals aren't always successful. As the other things, my intention is to grind it out. So I'm going to make them take this to the mat. I think the claim is righteous. I don't think immunity should apply, and certainly not to the non-monetary claims. And I think it's worth a shot. And I think I indicated to them during the proceedings, early on the proceedings, I said, if you push and should I lose, you give me the opportunity to make new law. So I could lose the appeal, obviously, but I could lose the appeal and a judge might open a door for future exemptions from immunity. In other words, they might say that, this might not be the case, but if these kind of facts arose in the future, we would consider excluding immunity under that set of facts. So I obviously hope to win the appeal, but notwithstanding that, perhaps we can get some language that will be helpful in the future. In the meantime, as the arbitration progresses, I will keep you apprised and continue to keep the pressure on, the collective pressure, because ultimately I still believe, and I've always said this, that the pressure will work. We just don't know when. So we all have to hang in. And I know for some that is really a difficult task, and I am sympathetic to that. I just try to provide my practical view. Could be wrong. Could be the ramblings of a madman, as someone once said. But that's the way I see it. So to the extent you can exercise patience while pressing, please do so. And by acting, it will make you feel better also. So anyway, so that's the update, arbitration update. I expect to have another one coming up sometime this week. Be well, take care, have a great weekend. See you next week.